The Crown has the burden to prove that the moral culpability or blameworthiness of the offender is more adult-like than a youth. And our basic submission was, with this young lady's severe cognitive disabilities, her FASD diagnosis, and various other factors, she has a lower degree of moral blameworthiness than the average offender, the average youth even. And so this is a young woman at the time of the offense who was 16, but for all intents and purposes was much younger in almost every way.
So is the youth old enough that she should be treated as an adult? And we're saying old enough, meaning mature enough, that she should be treated as an adult. The Crown is saying yes, she is. She is now 18, but she was 16 years old at the time. And we're asking for a life sentence. So I think it was important for the judge to hear from the workers at the federal institutions, the parole officers, the people that offer the programming, to show him what was available there and how that would be able to assist this offender in her future.
There's always other options available, but one of the difficulties with the youth criminal justice system is that it factors in so many different issues. Public safety is but one factor.
It is the Crown's position that a youth sentence is not long enough to hold her accountable, and in that terminology of accountability, it comes in the protection of the public to supervise her for a length of time until, if at some time, and there's never no hope. The fact that it was a baby just makes the crime seem more heinous because of the vulnerability of an infant. But I would be concerned, even if it had been an unprovoked attack, which this was, on somebody that wasn't an infant. With this offender's background and this type of action, this type of violence, whether the victim was an infant or not, this is the type of situation where the Crown would be seeking an adult sentence.